Good afternoon, everybody. Welcome to BW Legal World webinars, which are hosted every Saturday. I am Ritwika Nanda, partner Trust Legal, and I have with me Mr. Pramod Dubey, senior advocate, and we are here to discuss about the trial of Mr. Tarun Tejpal. Sir, thank you for taking the time out to join us today. We know that, firstly, congratulations on the judgment. It has been a well fought out for around 7.5 years now. And for my sake and for the young lawyers who've joined us today, sir, we need to take this opportunity to understand from you as to how a trial of this nature is to be strategized and be fought successfully, if I may add. Sir, we know that you have been an integral part of the core legal team who has been advising Mr. Tejpal since the very inception. When did you join the team to strategize on this matter?
Thank you, Ritika, and thanks to the business world given the opportunity to interact with you. First of all, I'll pay my condolence to my colleague, Mr. Rajiv Gomes, the lawyer, very young lawyer, 47 years old, and he left behind his wife and the young son. And the person who was basically associated with this matter from the very inception. When I joined, he also came at the same time. And after the charge and everything, he did the maximum cross-examination. He prepared for the final argument, and he was in constant touch with me for every strategy. So we lost. Basically, it's my personal loss, and unfortunately, he could not see the outcome of his hard work. So this is a very, I cannot say we can enjoy this verdict because this is the cost of we lost one of my colleagues. And not only that, Mr. Tejpal also gone through the very bad phase. He lost, when he was in jail, he lost his mother. Then he got the interim bail for the joining the last rites. But due to the some paperwork, he could not make himself available for the joining the last rite. Subsequently, he also lost his father. So it's a very bad phase and traumatic phase we have faced throughout the matter. So far as my joining the team is concerned, I joined at the very first inception when the case got registered, and we strategized to file the transit anticipatory bail before the Delhi High Court. And it was unsuccessful because initially got the stay, then again got dismissed. So, and that part I was here. And thereafter, they moved the application in the Session Court, Goa. Then, in between, the charge sheet was filed. When the charge sheet was filed before the competent court of the magistrate court, so the family approached me because there was a very peculiar circumstances. This matter was being held by the solicitor firm, and they were doing the matter in the very right way. They are putting their 100%. But when the charge sheet was filed, the London magistrate the same day committed the matter to the Court of Session while supplying the copy of the charge sheet. So there was a lot of panic in the family because they were deprived from all the exculpatory nature of the evidence. The prosecuting agency had deliberately not supplied those documents.
So I remember from my personal experience, I had come to brief you in a matter, I think sometime in 2015 or 16, and his family, very distressed, of course, was waiting for a briefing with you in the matter. So just before we come into the intricacies of the trial, there has been a lot of media coverage on this matter.
No, let me complete. The family approached me, and then I agreed to further continue with the matter. So when I was going through the charge sheet, it was very disturbing because a lot of materials, and Tarun was saying every time, these materials are very important, but unfortunately we are not having the document with us, and the court has not supplied. And clearly there is no provision before the session court to move the application for the supply of documents. So we were in catch 22. But I had the experience to get the document from the court of the session by moving the application for the supply of document in another matter. So I assure Tarun ki no, will get the document. So I moved the application before the session court for the supply of all the electronic media, like the clone copy of the telephone number of Tarun Tejpal, of the prosecutor, CCTV camera, and all the materials, whatever they have gathered. So ultimately, the session judge passed the order and directed the Goa police to supply all those documents. But they were not satisfied with the order. They directly came to the Supreme Court because Tarun's bail application was pending in the Supreme Court. So it came before Justice Sikri and Justice Rohington. But the Supreme Court upheld the order of the learned session court and passed the direction to know you complete the supply of the document. And they were taking the excuse, there is no forensic lab in India who can make the cloning of the, because they were deliberately hiding this material evidence from us. Ultimately, the Supreme Court, because Justice Nariman was well conversant with the electronic evidence, so he said, no, there is no rocket science behind all these things. This is the method. You send this lab and you will find this. Ultimately, they supply the document to us, and those documents, the entire case, turned on basis on those documents. So that was a very positive move, best strategy in the trial of this case.
So, sir, this was a new strategic turn that took in the matter when you were introduced into the strategy making team.
Yes.
We understand today that must have played a very important role, and I'll just come.
And that time I was leading the team. So whatever decision I took, because I was accountable to my decision, so ultimately we supported our decision with the help of the existing law of the land.
Yes, sir. Sir, but just before I have a few other questions to understand the intricacies for, of course, my benefit and for other lawyers. Sir, just this is what comes to my mind also a number of times, is that when a media report, when a matter is so widely covered in the media, and I'm sure before you were opted into the team, you must have read about this in the newspaper. So what happens? What is the perception? I'm asking you the perception, not a counsel's opinion. What is the perception that you have before, when you're reading it from the newspaper, and then after when you are drafted into the team? What is the change in the perception? Is there any?
See, I joined the office of my senior, who was dealing all the important cases of the day. So I was very well acquainted with this media trial and the pressure by the media. So I'm basically accustomed with all this kind of the environment. See, the question is, the media is doing their duty. You being a defense lawyer, you have to do your own duty. You have not to divert. You should not fall in trap of media. Yes. So the first thing which is required for the defense counsel, when there is a media trial, not enter into the reply with the media people. Number one. Number two, don't instruct your client to come in media and give so many explanations. You always avoid to give him any explanation and enter into any controversy in media. Thirdly, I remember one case where it was related with an eminent film actor. So he was being prosecuted under TADA. So he basically gave an interview with a senior lawyer, and he was number one criminal lawyer those days. And he made the confession in the media, yes, I possess these arms for my protection. And that confession became the extrajudicial confession. And that became one of the crucial evidence for his conviction. So we don't believe in going into the media, give explanation to each everything. And furthermore, this case is pertaining to rape case. And there is a certain guidelines of the Supreme Court, the Vishakha guidelines. There are certain provisions in the CRPC. You have to maintain the secrecy, the decency of the prosecutrix, and you should be more sensitive towards the prosecution and the prosecuting agency. So you have to maintain full privacy of the entire things. So it is incumbent upon the defense counsel as well as the accused to maintain the decency, respect, and privacy in the entire matter. So the moment you will divert and enter into the media front, then you will be affected and you lose your attention or all the energy. So one should never into the media things and not should be affected what the media is saying, because they are selling their story. So they are doing their duty.
Right.
They are collecting the evidence, and their evidence is not the gospel truth, because it is not authenticated by the court of law. So never enter into the media debate, media front. Don't use all these kind of the things in your trial.
So now, just elaborating a little on media trial, and we have seen the issue raise up in the recent past, where the Bombay High Court has also passed various directives against media trial. Right. Now this matter started in 2013. Then the Me Too movement gained traction in India sometime in 2017, 2018, sir. And at that point in time, I understand the trial in this matter was at its peak. As a counsel, sir, do you think there is a different strategy to be adopted when you know that issues that you're raising or arguments or the matter is going to be widely covered, and maybe the public perceived opinion was also at that point in time against Mr. Tejpal?
See, the Tejpal case is, as I mentioned, is squarely covered in the guidelines, Supreme guidelines, and the rape case. It's exceptional circumstances. And the beauty of this case, when I landed at a Goa airport with my team for the argument on charge, it was very difficult to enter into, because I was not getting a space, and 3-4 channels, they were so insistent, they were not letting us to go. And then they chased to our hotel, then they came to every time they were chasing, but we are not being diverted. And what happened, it is the prosecuting agency and the other people, the side of the prosecution, they were bringing the media people inside the court. So I made the request to the court, sir, this is that was the lady judge. I made the request, ma'am, this is the very sensitive case and related with the rape case, and there's the guidelines. So the entire proceedings should be in the camera trial. So there was no leak to the media from our side. And even the court of the CGM court, at the time of the supplying the CGM or ASJ, additional session judge court, at the time of the supply, there was an order not to leak the information to the media. So there was order, and then again the session judge passed the order, and entire thing happened in camera proceeding. So there was no question of trial being affected by the media at that time. Media was trying their best. There was some debate. There was a debate on Times Now. There was a debate on Republic. There are so many channels when the trial was going on. But we, as a defense counsel team, we never pay our attention to the media and what the media is doing and what they are giving the message to the society at large, because our focus was only to our defense and putting the case, assisting the court, and bringing all the truth before the court of law.
Correct. Sir, and it is very essential, like you said, I think, as defense counsels, to kind of maintain a distance from the media and not get influenced by it, because then it affects your performance in the court also. Now, sir, we know that an order was passed by the Sessions Court specifically restricting information to the media or media coverage in the matter. I think that is, I think, what you mentioned was a step taken. In such cases, sir, what are the additional precautions that a accused can take to insulate himself, at least to a considerable extent, from the media trial? Are there any additional steps that can be taken in such cases?
See, the tragedy in this matter, Mr. Tarun Tejpal is from the media family.
Correct.
And the media, the way the media behave with him,
Yes.
every time they are chasing Tarun Tejpal, his family, his daughters, his sister, his wife, his lawyers. So every time they are trying their best to bring something controversial, some controversial statements so that they can sell their story. But my advice to the accused person is that you should avoid the media as maximum as possible you could. You should not enter into the media debate.
Are there any other legal safeguards that can be utilized in this case?
Legal safeguard, you can see, this is basically pertaining to the rape case and the modesty of outraging the modesty of the woman, and there is a provision already there in the CRPC. There are 325 CRPC is already there, and we put the restriction on the trial, all the materials. If you feel aggrieved, then of course the option is open. You can move the application before the court, and the court will pass the order. If the court thinks necessary, the court will pass the gag order restraining the media person or any social media. In this case, duty, when we make the request orally to the court, this is the rape case, and rather accused made the request to maintain the decency and privacy of the entire decency of the prosecutrix and the privacy of the entire material. Immediately thereafter, there was the media news. The Goa court passed the gag order restraining the media. This is against the fundamental right. This is against the freedom of speech. We got surprised. What is happening in this country? You are not knowing the fundamental law. There is a provision. There is a Supreme Court law. Without reading, you are selling your story.
Right.
So basically, what they are doing, they were doing in plain Hindi word. They are basically वो किसी के कब्र को अपनी ताजमहल बना रहे थे. This was the irony of this matter.
Right. So now, of course, this matter involved an offence under Section 376 of rape. And I know for a fact that you have been involved in various other matters where this offence has been included. Is there any specific strategy or approach to move forward in this matter? As a lawyer, I'm asking.
See, Ritwika, these days, we are coming across so many cases where this kind of the allegations are coming, the persons are being prosecuted. So, being the defense lawyer, you have to examine each and every material meticulously. And you should bring all the substance, basically the evidence, like telephone chat, internet chat, your call location. So many things are available. And you see, in this matter, we got several materials from the documents supplied by the prosecution, that is the mobile phone of the concerned persons.
Okay.
And the information we got, which were the undisputed evidence, every information contradicts the case of the prosecution. The case which was orchestrated by the side of the prosecution, we had answer from the material supplied by the prosecuting agency that was lying in the telephone, that was lying in the CCTV camera. So we had ample evidence to establish that this case is based on the falsity, concoction and fabrication.
So the first lesson, sir, I understand is to be learned that as an officer of the court and as a defense counsel, it is first imperative that all the evidences be gathered and examined properly, not to be swayed. And that is how we have to start dissecting a matter. First, analyze the evidence that you have on record. Or if there is not on record, at least call for the evidence and take steps before the court to call for the evidences, like you said.
See, had we not moved the application before the session court for the supply of the evidence, the thing would have been changed completely.
Correct.
And he would have, Mr. Tarun Tejpal would have deprived from exculpatory nature of the evidence, which gave him clean cheat in this matter.
Correct. Now, so one thing, of course, my information about the matter has been from news reports. I'm hoping that they are correct, but they might be wrong. So please correct me if it is wrong. We saw from the news report that along with the charge sheet, the police had filed an email that was sent by Mr. Tejpal. And quote unquote, I'm again reading it from the news report. He wrote, "I apologize unconditionally for the shameful lapse of judgment that led me to an attempt a sexual liaison with you on 2 occasions, 7 November and 8 November, despite your clear reluctance that you did not want such attention from me." Quote unquote, I believe that this. Now, so what I want to ask is, more or less, this is what the allegation against him was. And before the charge sheet was filed, this email must have been sent by him. Now, sir, I'm asking from a legal standpoint purely. As a lawyer, as a defense counsel, sir, how are we supposed to overcome such an overwhelming, assuming this is to be correct, overcome such an overwhelming piece of document?
See, I'm very. See, Ritwika, I'm very fortunate I'm facing this question put by a person who has the legal background, who is experienced, and who is a senior partner in Trust Legal. So I'm very happy you put this question. See, if you don't take an email in isolation, if you go in the background and you will find the prosecutrix dictated the terms and the condition to Mr. Tejpal through the email. You write these facts under the letterhead of Tahalka. What was the need to write him on the letterhead of Tahalka? And if you are asking the apology at your terms condition upon your dictation, can you say that these were with free will? Can you say this statement was volunteer statement? If the statements, I'm not going the admissibility at this point. I'm not admitting this fact that Tarun Tejpal sent this email. I'm not going in this controversy. But so far as the legal aspect is concerned, if the maker has not made any statement, whosoever, whether Mr. X, Mr. Y, Mr. Tarun Tejpal or anyone, with his free will, voluntarily, without undue influence or the pressure or coercion, can you say this is the free statement and that would be treated as a confession?
So what
can he pass the litmus test of the extrajudicial confession? No. And there's a lot of controversy because the mail, then after 2 minutes again mail, 3 minutes again mail, when the mail was written, Mr. Tarun Tejpal having not the password, somebody also having the password, there is a lot of controversy. And this kind of evidence are not the admissible evidence, then can be the sole basis. See, as per the basic criminal jurisprudence, I'm not entering into those controversy because I have no occasion to go through the judgment. I have not gone through the judgment. So I don't know what is the finding of the court, learned court on this aspect. But in my view, from the very inception, this was not the piece of evidence, number one. Number two, for the sake of the argument, without prejudice to anything, even this could be the corroborative evidence. As per the criminal jurisprudence, you cannot convict a person on the basis of corroborative evidence. You have to first establish the substantive evidence, the primary evidence, then you go to the corroborative and secondary evidence. So the entire media hype was this email he admitted, made the admission. Where is the admission? This is not the admission at all.
So from a lawyer's perspective, sir, even when we see a piece of evidence like this, that also has to be dissected and seen whether at all it passes the litmus test or whether the requirements of admissibility are met or not. So clearly the arguments that you must have raised during the course of the matter would have found favor with the court, and that is why he has been today given a clean chit. Now, sir, this incident that was complained of, sir, it happened in a 5-star hotel. And again, news reports reported that the CCTV cameras in that hotel had captured the incident. Is that correct?
I would beg to differ with you. The incident was not captured by CCTV camera because as per the allegation, the incident took place inside the lift and total duration was 1/10 second closing, opening the lift, including closing up. So basically, in essence, 70 to 75 minutes second was there for commission of the entire incident. So
Okay.
the CCTV footage was the pre-conduct and the post-conduct of the parties, meaning by the prosecutors and the Tarun Tejpal.
So it is.
And from the CCTV camera, which was basically concealed at the inception by the prosecuting agency, gives the clean sheet to a stand of Mr. Tarun Tejpal. Because we cannot share the CCTV, it's a very sensitive matter and there is a restriction. But if I have seen, and from the CCTV, it is established that no incident had occurred, number one. Number two, the story which was made, there was a detailed conversation between prosecutors and Tarun Tejpal saying this, your daughter is my friend, you are this, I had the lunch, dinner with your wife, so many things. This could have not happened in this short span of 110 seconds. And lot of contradiction. The way the prosecutors have been cross-examined, the defense was able to prove she is not trustworthy witness, not the reliable witness. And you see in the rape case, the law is settled that mere statement of the prosecutor is sufficient to convict the accused if prosecutor is of a sterling quality, she is a reliable and trustworthy. So first you have to pass the litmus test of you are a sterling witness, reliable and trustworthy witness. Then your testimony would be the sole ground for the conviction of the accused in the rape cases. In this case, the defense was able to establish the witnesses, including the prosecutors, were neither reliable, not trustworthy, and not the sterling quality. And their testimony cannot be accepted, and trial court has rightly discarded their testimony.
Right. Now, sir, in today's world, we understand that electronic devices like phones, CCTV cameras, etc., play a very crucial role in the investigation. Now, sir, of course, you mentioned that if the CCTV camera did not actually capture the incident as had been portrayed by the media reports at that point in time, sir, then what is the extent of admissibility of this kind of evidence before the court? And what kind of a role did electronic evidences in this matter actually play a crucial role? Because you must have relied very heavily, as you said, that the prosecution had suppressed the documents and you had to move between various courts to have those evidences allowed. So what was the role of these electronic devices? And in today's world, how is it that a lawyer is supposed to approach in evaluating the sanctity of an evidence and to what extent it can be admissible and how much reliance can be placed on that?
See, first thing, you must be knowing there must be 65-page certificate if you are relying on the electronic evidence. Number two, and you are entitled for the clone copy of the material. And as per the latest Supreme Court judgment, you are also entitled to get the material examined through the forensic lab. So accused has also right to get it examined.
I'm sorry to cut you. How long does that take? Because in my experience, in a matter where
this is Ritwika, this is the software. Software, you put the material and you find within 10 minutes, half an hour. See, there is a lot of hue and cry. It cannot be done. It does not take much time. There is software is there. You put the material, software will give the wave formation, and everything would be there. Because they have to see the modulation, amplitude modulation, frequency modulation, and the tempering and the break. So this is for the sanctity of the material. Number one. Number two, you must be knowing if the prosecuting agency is relying upon an evidence, they cannot dispute the admissibility of that evidence. They don't have right. The doctrine of estoppel applied upon them. So in this case, we relied upon their evidence. So they had no occasion to disown those evidence because they had collected, they are claiming the sanctity of the evidence. So in this case, we could not get the opportunity, and it was not required to us to send this material for the forensic examination. We relied upon their forensic material. We relied upon their material. And of course, the entire Tarun Tejpal case got demolished only first on the basis of the circumstantial evidence, the second on the electronic evidence, and the cross-examination of the witnesses. On every aspect, the defense was able. If you see, if there is 100 allegations made by the prosecutrix, from one allegation to 100 allegations, the defense is able to demolish his he is not the trustworthy witness.
So, sir, what you are saying is that if the evidence that is presented by the prosecution is not that incriminating, you don't need to get it tested. But if it is incriminating, you should definitely get it tested.
No, if you have doubt, then you have the right, you can get it done. But you cannot only go, oh, this is the incriminating, so I'll get tested and I'll get the different opinion. No, this is not, I'm suggesting, and one should not suggest being the officer of the court. We should always be fair in the trial. See, the outcome of the case is the hand of the presiding officer who is conducting the case.
Correct.
Being the member of the bar, we should always be fair, assist the court, immaterial what would be the outcome of the case.
And
so
that is
so we are with the burden duty.
Yes.
Being the member of the bar to be fair always with the administration of the justice.
So in this case, how much role did mobile phone locations, etc. play? Did that play a pivotal role in establishing your defense?
See, we came across one evidence where there was a case of the prosecution. After the incident of 1 day after the incident, the prosecutrix left for Bombay, and she was not in Mumbai, Goa. But from her mobile location, we were able to find she was very much in Goa, and she was with one of her colleague on the sea breach. She stayed in Goa for quite long time. So this evidence also contradicts her statement given to the police and before the under section 164 also. So the mobile location, mobile chat, mobile exchange of the information, these all are the crucial witness, and it can help the prosecution or the defense. It's a depend upon the nature of the evidence. But there is every likelihood of the tampering of these evidence. If you go to the Grey Market, Khan Ghaffar Market or Nehru Place, you'll find, I was surprised, Ritika, they have the software. If you download the software in your mobile, even you are not using your mobile phone, I'll get the SMS in your name.
Okay.
You have sent me the SMS and these are the contents, though you have not used your mobile phone.
It's a boon and bane of technology.
Yeah, this is the technology. So you have to very meticulous relying on this electronic evidence. That's why the Supreme Court again saying, no, whosoever is the maker, whosoever is the custodian of the evidence must give certificate under 65B of the Indian Evidence Act.
Correct. So we know that framing of charges is a very crucial step in the process of this matter, of course. This session, after the Sessions Court order on charges which were framed, you appeal against that before the High Court and before the Supreme Court. And in fact, the Supreme Court dismissed the appeal, dismissed the SLP. Now, sir, what I want to understand is at that stage, what did you think would be the likely scenario? Were you satisfied with the decision of the Supreme Court, or did you at that point in time expect a different outcome?
See, there is no question of our own satisfaction. The Supreme Court is the apex court. whatever the verdict came, we had no option. We have to accept the verdict of the Supreme Court. So there is no question of satisfaction. But from the very inception of this case, our legal team was very much confident we will get acquittal. We tried our best for the discharge. I argued for a exhaustive argument addressed by me, that's the 4 days. And you'll surprise, I'm very conservative lawyer. I don't disclose my defense at any stage unless and until that situation comes. But in this case, we are so confident, we open our entire defense. We disclose our entire defense to the prosecution. We gave them a free hand. These are the loopholes in your case. These are the contradictions. Everything was given. Despite the fact, the defense, the team of Mr. Rajiv Gomes and some space Mr. Srikant Side, the defense team were able to demolish the case of the prosecution. We were quite sure that this is the fit case for discharge, but in any case, order is order. This is the appreciation by the court of law, and we have to accept the verdict. So we accepted, and we are never disappointed in this matter because we knew that this case will not stand at the trial. This case will 100% because we had ample evidence to demolish the case of the prosecution.
Right. So the lawyers are the best ones to know the position as to the status of the evidence. And sir, another thing that I want to understand is the incident that was complained of happened approximately on 7th or 8th of November. The FIR came to be lodged sometime on the 22nd of November or so. Now, sir, what I want to understand from a legal standpoint that and I understand that the FIR was also lodged, the complaint was made by a third person. So what is the effect of a third person complaint in such a matter? And also there are various statements that were recorded by the police after filing of the charge sheet. Apparently, a lot of friends came up and said that we had heard this incident over a period of a number of days. So, two questions that I want to understand is what is the role of a third-party complaint? To what extent can that influence or affect the proceedings? And the second thing is, how do we determine as to the conduct of the complainant, conduct of the prosecutrix in this matter over a period of days? Is it correct that she will go? Anybody will go around citing or narrating the incident and thereafter creating? Do we call that creating of witnesses?
See, let me answer the first question regarding the locus of the third party. In the criminal jurisprudence, barring some few special act, the provision in this few special act, there is no bar to become the informer. Rather, there is a provision in CRPC section 49 CRPC that if you are aware of the commission of the cognizable offense, it is your duty to inform the police. So there is no bar, anyone can put the law in motion. So this is one aspect. The second aspect, this is not happen in this case. This is a very peculiar case. After the alleged incident, we came across the evidence where there was a proper communication among so many people. The draft was circulated, then they gave their opinion, they were waiting, and then there was an interstate discussion between the parties. Should we file the police complaints? Some suggested, no, don't go directly to the police. Just bring this fact in the social media, let the social media start hue and cry, then the police will automatically take the complaints. And this happened in this case. So there are a lot of deliberation, the legal consultation, the lawyer gave the advice, the lawyer's office gave the advice, the lawyer, female counsel was there, very young female lawyer. I'm not talking about the senior lawyer. who were chatting, how we'll put in the social media, then we should take the route of the social media. See the history and the Malaf ID and the purpose behind all the things. So this started in this way, and the Goa police came, the Goa police started the investigation, and immediately they recorded. And so far as the consulting the other person and their statement are concerned, you must be knowing that these all statements were the very belated statement, and the legal terminology, the hearsay evidence. They heard, they were not the eyewitness, they heard. See, in a rape case, even you are making the statement before some third person immediately after the offense. The test is immediately after the offense. The moment you came out of the company of the accused, the test is you are required to make the statement immediately after the first person you made. In this case, that was not done. It was done after very long gap. And how the people got collected, then the disclosure was made, then it went. So many things happened. So the testimony of their statement and whatever they have made did not pass the litmus test. The test as prescribed in the Indian Evidence Act. We cannot go with perception, the social perception. Even we cannot go rule of the evidence. We have to strictly follow the evidence, Indian Evidence Act. And it is the burden duty of the prosecuting agency to prove their case beyond reasonable doubt. In this case is based on the doubt. Everywhere there is a doubt. One doubt is sufficient for the acquittal of the accused. This is the criminal jurisprudence. But the foundation of this case is based on the doubt, ended with the doubt. Everywhere doubt.
The essential learning that we had today is to understand the timeline when the statements were made by the complainant and the witnesses who had come forward as to at what point in time they had heard of the narration and whether they can be admissible. We need to deal with that also. Now, sir, you mentioned that it is on the prosecution to prove beyond reasonable doubt, but sir, I understand in the Indian Evidence Act, in matters concerning Section 376, rape, etc., the presumption is towards the complainant. That if somebody has said that an offense has occurred, the presumption in law is in their favor. So, sir, in this case, how did you overcome that presumption?
Thank you so much. You have rightly put this question. I appreciate your questioning me. You see, Ritwika, 114A, you cannot read 114A in isolation by saying there is a presumption. The nature of the presumption is rebuttable presumption. The moment the word rebuttable is there, so your onus lie upon you to rebut the allegation, rebut the facts. So the first onus lies upon the prosecuting agency to prove their case beyond the reasonable doubt. If you are able to prove the case in four corners of the law laid down by the legislature, then onus lies upon the defense, the accused, to prove that no, I am innocent and this offense is not committed. In this case, the foundation, the fundamental of the allegation has miserably not been proved by the prosecuting agency. Where is the question of the rebuttal by the accused? There is no question of the rebuttal by the accused. Rather accused, the team of the Mr. Tejpal, the defense had gone further. Whatever was required under the law to establish that the entire case is false case and there is not a single legally admissible evidence.
So the first threshold could not be covered by
cross. Of course, you have to cross the bridge. You have to cross the threshold by proving beyond the reasonable doubt in four corners.
And that is when Section 114A comes into play on the presumption part of it.
Yes.
But often it is confused that 114A will prevail over the reasonable doubt.
Yes. If you have proved guilt, offense, then onus, of course, the onus lies upon the accused to prove that I have not committed. If he has really not committed, if he has committed, there is no question. If he has committed, no question. But once he has committed, he already got the opportunity at the time of the framing of the charge, whether you have committed the guilt or not, whether you are claimed to be tried or not. If they are saying, I am not committed, I claim to be tried. So the 114, we cannot give the narrow and the conservative interpretation of 114. The first onus lies threshold upon the prosecuting agency to prove their case, then shift the burden. Prosecuting agency cannot extend the legs of the accused by saying, there is 114. 114 will come. Subsequently, first you discharge your duty onus. Prove the case against me, then I'll come forward.
That is an important, essential point to understand and learn, sir. Sir, I'll quickly conclude, but are there any other challenges that you think you faced which were unique to this case, and maybe it was a new learning for you also?
See, every time being the student of the law, every time we are in the process of learning. And this is also the learning experience. I learned a lot. I got a best support from my legal team. I got interacted with so many legal luminaries, discussing the matter with the top lawyers, interacted with my clients, developed the argument. So I was there till the final decision by the High Court on the point of the charge. Then some other outstation counsel came, and then Mr. Rajiv Gomes, being the local, he was very brilliant, dynamic, hardworking, courteous, focused, and he was very supportive to me. He extended all his assistance to me whenever I required. And whenever he found any ambiguity, any confusion, without any hesitation, he was calling me. So it was a good experience, learning experience. And I'm very thankful to the court also. The court appreciated the material in the right direction, despite there is a media hype and there's a lot of pressure.
So now, just to conclude, this is something I have to completely ask. Now the thing is, again in a news report, Ms. Ramani got a favorable order from a Delhi court recently in an allegation which was revolving around criminal defamation. And if I quote unquote again, the news report said India's Me Too movement recently got a boost after a journalist won a criminal defamation case against editor turned politician. Now, sir, what do you think? Do you think that the taglines, which the verdict was delivered yesterday, the judgment is probably still not out. Do you think that the new tagline that is going to read that India's Me Too movement recently got a blow or something like that?
See, at the inception, I have already mentioned that I am a very conservative lawyer practicing in the criminal side. I would have not advised Mr. in Ramani case to file a defamation case, because the moment you will file a defamation case, the onus lies upon you to prove the case, and you will be subjected of the cross-examination.
Correct.
And the other party can cross-examination, conduct the cross-exam at any length. They can put any question, they can enter into the private life and your private domain, and they give the opportunity in this case. But Ramani case, what I got the occasion to go through the order passed by the London Metropolitan Magistrate, in this case, a special Metropolitan Magistrate. The finding has no coherence with the evidence. You are taking the examples from the Mahabharata, the Gita, Ramayana. This is not the codified law which is prevailing in this country. You are taking and you are coming to the conclusion with a presumption. Rather, you are holding the complainant as a guilty. So these all are unknown in the criminal jurisprudence. I don't agree with the judgment passed by the London Trial Court. So I cannot accept that this is the blow and everything, being the lawyer practicing in the criminal side, and still the matter is in the adjudication before the appellate court. So it has not attained the finality. So it is premature to make any comment on the verdict. So I don't think this is the complete the blow and anything. Ultimately, you have to go through the rigors of trial and proving the case as per the Indian Evidence Act.
Yes. And so the Goa government has already announced in the media that they are going to be appealing against that. So
I'm very happy with the statement when I heard yesterday the London special prosecutor made the statement it's a setback for them. So I'm very happy. This setback came to my client in 2013. It came to us when the charges were framed. Now they are meeting this setback, and they have the right to file. They have right to file the appeal. Let them file. Let them file. Let them exhaust their remedy. But their personal perception cannot be appreciated. Ultimately, it would be examined by the court of law. If they first they have to file the appeal, satisfy the conscience of the court whether it's a fit case for granting the leave to appeal. So they have to cross so many bridges, and I don't think this is the fit case for appeal. The way the trial has conducted, it can be said that this is the instant reaction. When they will read the evidence, appreciate the entire judgment, then I think the wisdom will prevail over them not to file the appeal. Let us say.
But sir, that is a remedy that is available to them, and
of course they have remedy. They are well within their power to avail that remedy.
Right. Sir, of course, one leg has been fought. I think 2 other legs before the High Court, Supreme Court still remains now. But you mentioned about the loss of your colleagues. We are, of course, in these terrible times, very sad to hear such a news. Be that as it may, sir, thank you so much for joining us. We did understand quite a few intricacies and how to approach in a matter like this. It has been an eye-opener. Thank you for taking out the time for joining us. And for all our other members who have registered and are watching this, thank you so much.
Thanks.